Welcome to Premium Cashflow Real Estate Investing Podcast with Sakar Cowley. During this program, you will hear guest experts sharing their experiences, best practices, and market insights. We discuss investing in multifamily apartment complexes and how a busy professional can passively invest hassle-free in various opportunities. Your host, Sakar Cowley, owns millions of dollars of assets and has done thousands of value-add projects over 20 years now. So listen in for insights. Here's your host, Sakar Cowley.
Welcome to another edition of Premium Cashflow Podcast. I am your host, Sakar Cowley. Today, I have the pleasure of welcoming Brian Bradley with Bradley Legal Group. Thanks for taking time, Brian. I appreciate it.
Thanks, Sakar, for having me on and putting the podcast together. And, it really is a big topic, but it's going to be necessary for everybody investing in your high profile, high risk, listeners. And I hope that these key concepts and the roadmaps we go over, really help them out.
Sure. Thank you. Thank you. I appreciate your expertise today. So, Brian, as you are an expert in asset protection, give us some background in terms of, how you got started and how you came about into such a big force into asset protection. And now you have so many high net worth clients that you advise and act as their advisor of sorts. So give us some background, please.
Yeah. So, like you said, I'm an asset protection attorney, and I got into asset protection from the litigation side of law. I'm going to court and representing clients and having, my clients being sued and their lives just turned completely upside down with not much that they can do or were able to do about it, having false sense of securities that their insurance providers were going to be there to cover everything, or that they had a revocable living trust and they found out that, a revocable living trust isn't there to protect them. It's just there for, avoiding probate when they die and identifying who gets what. So there's no real protection teeth into it. And I just got disgusted by, all of this and wanted to help clients before they were attacked and before they needed asset protection. And the sad thing is just that the legal system, from practicing it is broken, and it's not about justice any longer. The American Bar Association estimates that there's more than 40 million lawsuits that are filed every year in the US. Yeah. And real estate law is the most heavily litigated area of law. And the legal system has become more of a redistribution of wealth system that's encouraging plaintiffs who risk nothing to sue anyone to try to get a payday. And so it's a sad thing that the civil litigation has become $1 billion business and industry, and hardworking individuals who are saving and investing are the prey. We're simply just a sue happy nirvana. And so what I do is provide peace of mind for clients, and, while keeping in mind our overall goal really for asset protection is lifestyle preservation and changing the way predators view you. And more importantly, how collectible you are. You can't stop yourself from being sued, but you do have control over how collectible you are. And so what my firm specifically does is work with the higher net worth clients and the high risk professionals like doctors and real estate investors who hit that 1 million net worth mark. And though that level will come with a higher initial startup cost, generally around $29,000. On the flip side, their profile and their needs, their exposure and their risk and visibility are a lot more. Sure. So in our network, we protected collectively up to over $4 billion worth of assets in the systems that we've created.
Wow. And I can personally relate there, Brian, that I have seen, obviously multiple of such cases. And more importantly, there is this practice of, advertising for looking for malpractice or looking for any type of accident that may have created, or perhaps, just looking for a negligence of sorts and things like that. So there's this whole web of things that are out there. I mean, here in Maryland, where I am based, and I've been doing real estate for 20 years, and I can pretty much relate to like how much time and effort we take in terms of we have a unique situation here from a lead paint situation that we have to get our properties not only just safe from a lead paint, we have to get them lead free, which is basically the gold standard that there's no lead paint exists, because we have seen plenty of case law before as well, where a lead paint lawsuit in a real estate portfolio can be very expensive to defend. And more importantly, if you lose, I mean, how much things can be wiped out. I'm sure you've seen some of those cases as well.
Oh, no, I have. And it goes to really just what's changed over the last 30 and 40 years. You know, like the litigation landscape's just completely changed. And things that I think is because things that didn't happen in the past or weren't allowed to happen in the past, like contingency fee lawyers or law firm advertising, is commonplace now. And this created a law firms that are just purely sales and profit driven versus a justice driven legal system. And it just no longer is about justice, but just profits and hiring, you know, all the sales and marketing tactics that they have just to, you know, be profitable. And so asset protection has become the modern best bet and attempt to level the playing field. And by using all the different legal tools that we'll go over at different stops along the road, that's what helps level your playing field and makes it very hard for creditors to collect on you. This then puts you in a lot stronger position at the negotiating table and gives you the stronger leverage to settle or force claims, or to have them completely go away, especially if you're getting into higher levels of asset protection, like asset protection trusts.
Sure. So let's go in there. For starters, Brian, help us explain and kind of break it down, like what it means to protect your asset or asset protection, the term, right? And go into, let's say, what it looks like for a simple person versus a high net person versus a very ultra high net worth person.
Great, will do. It's a great question. So it's really misunderstood, you know, the term asset protection, and partly because most people just have never heard it before. They watch movies and, you know, they hear about Panama Papers or other scams on TV, and they just lump everything together. Right. But asset protection isn't traditional estate planning. It's modern estate planning. And the term itself became known in the 1980s with asset protection trust coming about. And then recently it became more of a standalone term and specifically in its own specific area of law. Even the ABA now recognizes asset protection as its own subset of estate planning. And we teach courses on asset protection. You learn about it and take CLE, continuing legal education courses on it. And what we're doing with asset protection is placing a legal barrier between your assets and your potential creditors. That's it. Like a barrier, like a safe for your gold or your guns. Anything of value you want to put behind the barrier so that it's not easily attached or with a lien or reached or attacked with lawsuits. And as long as it's done proactively, which means before you're being sued, the courts don't have an issue with it. You know, they actually encourage you to be proactive and take steps to proactively planning. What courts don't want is you committing fraud or avoiding taxes or being secretive and hiding assets. That's when you start seeing people get in trouble.
Interesting.
Yeah. And so the roadmap here is going to have different stops along the way, depending on where you are and what your profile looks like and what your assets are. But the entry level point for asset protection is going to be have insurance and an LLC. You know, like that's your basic entry setup. And an LLC is a good entry point to establish some basic level of protection. Once you've maxed out your state and federal exemptions, like homestead exemptions for certain states and your ERISA defined benefits, you know, like 401ks. What you're starting to do now with LLCs is protect those non-exempt assets. You're getting those assets out of your personal name and starting to create a moat around your castle. And so everybody's heard of LLC, so I don't think we really need to like jump into like what specifically is an LLC. Right. I do think what is important to understand and the big issue is the battle between legal and proactive authority, especially when it comes to LLCs for real estate investors. And this is why we start using higher levels of asset protection once you hit around a $500,000 mark, net worth mark.
What do you mean by the battle between the legal protection and the priority that you just said?
Yeah,
there, Brian?
Yeah. So legal versus practical authority. It's the reality is that a judge can and does do whatever a judge wants. So
Absolutely.
LLCs and limited partnerships, LPs, they're governed by the state statutes where they're created in. And when you get sued, you're not going to be able to transfer tort or damage loss from one state to another. So if you get injured and have a property in, for example, like Wyoming, and you live in California, you're not going to be able to transfer those laws. Or if you live in California and you have a Wyoming LLC, just because that California property is held in the Wyoming LLC, you're going to be getting sued through the state damage and tort laws where the injury happened in California. They don't transfer laws like that. So I think that's a big misconception that people have.
Interesting. So you're saying there, Brian, just to correct, is if you own a property, it doesn't matter where your LLC is based out of, right? So like, for example, in syndication world, people are constantly using, let's say, the Wyoming LLC or the Texas or the Florida for all different reasons, right? So you're saying basically that, let's say if someone has an asset in whichever state, that's where the rules will start. It doesn't matter where your LLC is formed or organized.
Correct. It's called the site. It's called the situs, and that's the injuries, the jurisdiction, and then those state laws, wherever the lawsuit and injury occur, are going to apply. Business laws, like if you and I, for example, own an LLC together for a business venture, and we live in Nevada, and we created a Wyoming, LLC. In business disputes, we can use the Wyoming business statutes that were there because it's a business dispute. It's an internal dispute. But when you go outside an external dispute and it's an injury case, the laws and the injury laws and the tort laws and the damage laws are going to come from where the state that the injury happened to and the assets at.
Good. Thank you for clarifying that.
And then
if I may, Brian, on the topic of LLCs that you said, although you're absolutely right, there is, preliminary definition. Everybody knows lots of things around LLCs and stuff. Where I want to maybe perhaps have you comment your expertise is that in a case or in a lawsuit, right? This whole corporate wheel, or like you break the wheel of the LLC, and I have heard comments where there are certain best practices about how you form the LLC, meaning the membership, and how different members you can contribute, so that there's no direct path to one person or two persons' assets. Like like a weak example would be a husband and wife, owning the LLC. Well, in that case, for example, it would be one and the same thing, right? But let's say if you involve some unrelated member, like let's say brother-in-law or some other folks, could you maybe give us some thoughts on what do you think about that?
Yeah. So I think of what you're asking is single member versus multiple member ownership of LLCs, and then some charging order.
Exactly.
And piercing the corporate veil. And so when you're creating an LLC, it's a great entry point, like I said, and it's because it's in its name, limited liability. But you also have to understand that it's in its name, limited. Like there's only so much protection that you can have. And then whether you own an LLC as a single member or a multi-member LLC, generally, if you're going to own real estate, we recommend that you own a single member LLC to own the asset in. And then what you're really looking at is charging orders. And that's where people are jumping around for, different jurisdictions like Wyoming, Arizona, Nevada, Texas. What charging orders means is that depending on the state and the jurisdiction, you can either have really strong charging orders or horrible ones. And what is referring to is how much a creditor can actually collect from you, the owner of the LLC. So good state charging orders have the charging order being the sole remedy. That's it. You're not going to be able to go outside that LLC. Basically, a creditor with a judgment against you or the LLC or the member of it is entitled only to that limited remedy of the charging order.
I see.
The problem is when we get into called practical authority. What practical authority refers to is the power of a judge and what they actually have and the power they have to make decisions. A judge has a superpower called the court of equity. And so that means a judge has very broad powers to reaching your assets, including seizing them, placing a lien on them, foreclosing on them, ordering a sheriff's sale, clearing title, wage garnishment is almost endless. And
I know that's what I started to think, that, I mean, the judge has pretty much unlimited power in terms of what all different stipulations they can place, you know?
Exactly. And the problem is they do this even without legal authority to do these things. They do that by exercising their superpower called the court of equity, because their whole job is to find an equitable resolution.
Sure.
And they do this even in direct contradiction to established statutes and case law. You see it all the time.
Sure.
So the result is that court's practical authority just took your asset, even with no legal authority. Right. And so the solution is to hinder a judge's practical authority over your assets so that they can't circumvent the legal process. And so you can see charging order shopping is only so strong, and especially in the U.S. system where we have the full faith and credit clause of the Constitution. Anything purely domestic, you can't ever avoid the Constitution, the full faith and credit clause, and you can't ever avoid a judge's superpower authority. And so what we need to do is try to level the playing field, and that's what stronger asset protection systems do. Like using asset management partnerships, and then bringing in the big guns, asset protection trust. And that, you know, we bring in the asset protection trust generally around when you hit that 1 million net worth mark. Interesting.
Can you maybe explain us about, you know, the asset protection trust and also the asset part that you just said, Brian, there?
Yeah. So let's say you become somewhat successful. You start out with your LLC. You have about 2 or 4 of those, probably like 5 units. And so you have maybe a couple LLCs at that point. It's starting to get hard to manage.
Sure.
And so the next level up is you create an asset protection management limited partnership. What it is just a management company that owns those LLCs, and those LLCs own the real estate. And so what this does is it makes your CPA not hate you, because you now have only one tax filing, because all those K1s go through that limited partnership, that management company. And so it makes it easier to manage. And now it's creating a second layer of protection because you're managing through that management company.
Sure.
All your receivables go through there. That's going to be your name. That's going to be the branding.
Sure.
And then when you get to your third tier, your outer layer, that's really cold outside, it's winter storm, you know, we have over $1 million worth of net worth or more, you used an asset protection trust.
I see. So going back to the prior example that you said there, Brian, that you have an operating LLC and you have assets in some other LLCs, right? So let's imagine a dark scenario that you had a lawsuit, and obviously it comes through, let's say, your operating entity, right? What is it that prevents the judge to say that, hey, listen, you know, this operating entity is truly just a shell. I'm going to go after the actual, you know, assets that are owned in that LLC. Could you maybe shed some light on that piece?
Great question. At that point, nothing, because it's just going to be as strong as an LLC.
Right.
What you're doing is trying to create a second separation layer of your asset with the LLC into a management company. So at that point, there's not going to be any additional protection from the LLC. What it is scaling you up to where if you're already are becoming a successful investor, for us to add the asset protection trust onto it. So the management company is going to be a limited partnership. All right. Those have 2 separate ownership classes, a general partnership owner and a minority partnership share owner. All the LLCs and real estate are going to be owned by the general partnership, and you're just going to be named the general managing partner of that. So you're just managing the business. And
I see.
The ownership share of that management company is the minority portion of the limited partnership. That is going to be owned by your asset protection trust, or your bridge trust that we like to use for, you know, higher net worth clients. That's the ownership share of it. And that's your really strong asset protection, because it's both a domestic asset protection trust and it's a foreign asset protection trust all in one. And you want that foreign component because the strength of the jurisdiction of being offshore, because nothing domestic, you can't say, sorry, we're not going to recognize your court order or your judgment. But if you add an offshore component like the Cook Islands have what's called statutory non-recognition. They're going to say, sorry, we don't recognize any countries or states or other governments' court orders or damages you have to sue us. You have to start the lawsuit here in the Cook Islands. And so that's why when you look for strong asset protection, and jurisdiction is so important.
I see. So you're saying basically that not only you should have a domestic component, you definitely add a foreign component wherein it's almost impossible to like consume the whole pie, so to speak, right?
Correct. And that, I'll go for it. Sorry.
No, I was just going to ask that between the operating LLC and the ownership LLC, as I like to call it, is there any other barrier we can, or any other gate we can put in between them that prevents sort of jumping the fence of sorts for a judge?
At that point, if you have that whole setup with the LLCs owning the real estate, then the asset management limited partnership owning the LLCs, and you come in with a bridge trust, which is also a foreign asset protection trust, that is one of the strongest systems that you could create. You don't really need much more after that, because what happens when you have that foreign component is, even in the worst case scenario, let's say you have a $10 million judgment, an actual judgment against you. They have to go to the offshore, trustee in the Cook Islands and say, hey, I have this judgment. At that point, that offshore trustee is going to say, well, sorry, we don't care because we don't recognize other countries' court orders. You're going to have to start the lawsuit here from scratch within 1 year statute of limitations, prove the case beyond a reasonable doubt, pay all the upfront court costs, fly in a judge from New Zealand, and if you lose, you pay. So it's the ultimate barrier, and it's been around for over 40 years, and it's still the gold standard. And so with that strong of an asset protection system, even if you get a U.S. judgment against you, once the assets are triggered and we drop the domestic compliance and we're purely a foreign Cook Island asset protection trust, it forces even that judgment holder to come back to the negotiating table and settle that case for pennies on the dollar, because they realize they're never going to get a penny otherwise.
Sure.
You're in the position of strength and leverage, even against a judgment on you. And so when you're being sued, when we decide to trigger that clause, the migration clause, to drop domestic compliance and be purely classified foreign, is just a strategy during trial.
I see. Now, Brian, help us explain the role of insurance in all of this, right? So you have your primary insurance, right? And then one can argue that, hey, why am I going into a complicated setup? Why can't I go into adding like an umbrella insurance or something into this, right?
Yeah.
So help us now sort of break it down into pros and cons of why would you do or why would you not do the sort of the umbrella insurance route, as I call it?
Yeah, no problem. It's a great question, and it's a good, one that's commonly misunderstood. And this is definitely a hot topic. And insurance, like I said, is always a great place to start. Have insurance, have as much coverage as you can have. It helps for small claims, but if there's a big claim, a building burnt down and someone died, or your business is being sued for tens of millions of dollars, your insurance job is not to sit there and cover you. It's there to create legal wiggle room to not cover that large claim. Their job is to collect premiums and not pay large claims.
Sure. And that's where I kind of sometimes think that's where your umbrella should also probably trigger in, right? And again, as you described, right, if it's a large building loss with multiple losses and stuff, so I don't know, I mean, but that would be pretty disastrous, that if you have multiple lives being lost, I mean, like let's say if you had an apartment building catch fire, this can unfortunately happen. I mean, we really don't want those things to happen. But hey, in practical life, let's say that happens. I would be interested to know your thoughts that how far the umbrella insurance can go. And that's where I think your asset management trust, as you said, would probably come in. But I would love to get
backup. Yeah. And the issue with insurance is they don't cover you for fraud or intentional wrongdoings or intentional acts. Right. And so the simple part of it is this: the way insurance defense works is that a simple statement as an email that I sent during, before a lawsuit, even the plumbing is all done, is all perfect. That's a statement. What a judge will say is, well, you sent an email, that was an intentional act. And now your insurance provider is going to say like, oh, well, now this case may be all based off of intentional wrongdoing and intentional acts. even an umbrella policy, we don't cover you for intentional wrongdoings or intentional acts.
Sure.
And if you think we're wrong, go ahead and sue us also. But now that the judge deemed this potentially an intentional act, we're not going to cover you. And that's how insurance defense and in the insurance business itself works. And so you need to, your listeners need to understand, insurance is great. Have it is good for the little things, but it's not going to cover you. And they're going to create legal wiggle room to not cover that. And insurance realistically only provides capital for lawsuits in litigation. Generally, all that's eaten up in large lawsuits through the lawsuit. Now, if you have an over coverage claim amount, let's say you're only covered for 1 million and the damages is 5 million, you're going to still have to protect yourself for that 4 million left over.
Right. Now, in your solution that you said there, Brian, the asset management trust and the, let's say the domestic component and the international component that you described, give us some sort of what's involved in structuring these, like the paperwork, are there any resident agents that need to be involved, or can they be still US-based agents? Give us some framework on what sort of details are needed to establish this framework.
Yeah, and so the bridge trust that we use is going to be held in compliance with the IRS codes, especially. So all asset protection trusts, let me start it like this, are called self-settled spendthrift trusts, whether they're domestic or foreign. And it means that they're created by you for yourself as your own beneficiary. And then a bridge trust is just combining the best of both worlds. It's combining a domestic component so that it's cheaper on maintenance. It's cheaper while it's purely domestic. You don't have to do all the IRS foreign disclosures. It's a lot easier to maintain. And then this is all through compliance with US Section 7701, which is the court test and the control test. And and so I wouldn't recommend anybody setting these up on their own because they're going to completely mess this up. Like you have to go, so you need to have a lawyer, an asset protection attorney who's familiar with both domestic and foreign asset protection trust. You're going to have, for example, an offshore foreign trustee. You're going to have a trust protector looking over the foreign trustee. You're going to be the named trustee while you're purely domestic. You don't need to set up an offshore, like Swiss bank account at that point in time because it's not needed. You don't need to spend on that. What happens is if you get sued and we deem it's necessary to trigger the bridge and cross over from domestic to the foreign component of it, is that IRS compliance of Section 7701 is just dropped. We no longer name you as the trustee. Your backup offshore trustee is now the main trustee. And you want that to happen because you don't want to have a US court say, well, I know you own assets here domestically and we want you to bring them back and we're going to hold you in civil contempt until you do. What the power of having the trustee take over, the offshore trustee take over and removing you as the sole controller is you don't have control to do that anymore. And that offshore trustee is going to say, well, hey, this is under duress. Our job is to protect the assets. So no, we're not going to comply. Even if you, the settler of the trust say, hey, can you please comply with that and transfer the assets back? And this is established through case law. They're just going to say no because it's duress and we're not going to adhere to that. We're protecting the assets. And now a judge won't be able to hold you in civil contempt and force those assets back. And then, and then they ask, the lawsuit settles, it goes away. Once it goes away, we reinstill the IRS compliance and now it's back to being purely a domestic classified trust. And so that's how the inner workings and tactics of it work.
Right. So now, Brian, I want to shift attention to something that practically happens day in, day out. I'm addressing the real estate investors here. They're doing a lot of deals and, establishing a lot of LLCs, a lot of entities get established from deals to deals and things like that, right? So in your asset protection or the bridge trust, as you said, does it need to be entity specific, meaning let's say a lot of multifamily operators are establishing, as I said, sort of apartment specific entities, right? So is there any umbrella structure that can cover a lot of these things, or unfortunately, if the answer is no, what sort of tactics you have played when someone has a lot of entities underneath them?
So we clean these up with the management company, because sometimes entities can be combined or disregarded because they may not be needed.
Mm-hmm.
That's what the management company's for.
Mm-hmm.
And it just makes it a smoother business for them to run.
Mm-hmm.
And then the asset protection trust is going to be, it's a grantor trust, an irrevocable tax neutral grantor trust. And because it's a grantor trust,
Mm-hmm.
it doesn't hinder anybody's ability to continue investing how they want. So you can keep investing however, running your business however you want. It's tax neutral because we're not, again, asset protection is not about avoiding taxes. You're going to be paying your taxes on it.
Mm-hmm.
But as you're adding all these LLCs and different business entities and investments, you want a more streamlined process to manage it. That's the management limited partnership.
Sure. So that would be addressed just right at the management entity level. That
Correct.
those are kind of the sub with there for the management LLC.
Correct. And then the bridge trust, which is the domestic and foreign trust, is your big shark protection system. Like you really don't need anything above that, because you have in your back pocket the foreign Cook Island option if you ever needed to trigger it.
Mm-hmm.
Generally, I hope you don't. Like we've had to trigger over 100 of them, and they all work. It works out perfectly fine and makes this cases just go away or settle for pennies on the dollar.
Mm-hmm.
It's just you have it in the back pocket if and when you ever need it.
I see. Mm-hmm.
Yeah, some people might want to create a second LLC, like you have your management company and the bridge trust above it. Some clients may want to create, for example, like a Wyoming LLC as a buffer between the management company. But generally that's just overkill and it's not needed, because you remember, whatever you set up, you want the optics to look good, because if you are in court in front of a judge or a jury, you don't want the optics to look bad, because then you are going to make people angry, whether the system's strong or not. So you just always want to look through whatever you create, make sure the optics look good. Just like that's why you use LLCs in the states where you own the assets in, better optics.
I see. Now, Brian, here, are there any tax deferment benefits or any of that sort in the bridge trust, or it's more for classification of assets and protecting them?
Yeah, great question. Its main focus is purely protection. Anything that you set up for asset protection needs to be tax neutral, just to protect and preventative planning. That doesn't mean you can't get tax benefits, because, for example, if you own something in your name and you take it out of your name and you put it into a business entity, the IRS now views your facts differently. So you're going to be taxed differently. And generally, then you're going to get the benefits of different tax write-offs that your CPA will be able to utilize and cost segregation studies, and you'll be able to get more money in your back pocket.
Sure.
That's secondary. So we don't plan around that. We plan for the protection part of it. And then we work with your CPA on the secondary tax benefits of it. Our viewpoint of it is this isn't for tax avoidance. Otherwise, it's
Right. Now, going back to the bridge trust there, the foreign component that we add, are there any annual continuing requirements to maintain that there?
While it's domestic, it's about $2,100 a year maintenance, and that's for the management company and the bridge trust. And that's about, that's our cost, and that's about generally across the board. If you ever had to trigger it and drop it and be a purely foreign asset protection trust, then you're going to go into a higher maintenance cost, generally around $5,000 to $10,000 while you're purely foreign. And you're going to have to comply with the IRS foreign tax filings and disclosures. And then when the case settles, once the domestic components are added back in place, you're going to go back down to the lower maintenance cost fees, and then you don't have those extra IRS foreign tax filings.
I see. So now, Brian, what sort of costs are involved in setting up the bridge trust, and what sort of paperwork and how much time it takes to set this up?
Yeah, generally, like our firm, I don't know what every firm does, but across the board, most firms will work like this, and I'll just do it through what our firm does.
Sure.
They're going to just give you a flat rate. And we do it because we don't want people to have to worry about extra hourly costs. So for the management company and the bridge trust, it's $29,000, $6,000 for the management company, and then $23,000 for the bridge trust. We do all the legal documents for you. We help you to transfer everything over. All of this is done within about 30 days. We're very efficient at it, and you're not lawyers. We don't want you to be doing it and messing it up.
Sure.
So you just work with the legal department and we do everything for you. Most firms will do that. Also, I would be hesitant if they weren't to work with you and just say, here's a blanket empty trust. Good luck managing it on your own and transferring everything into it without knowing how to do it.
I know.
You're just going to mess up a very strong system and you're not getting what you pay for.
Right. And also now, Brian, speaking of the trust structure, what sort of success you have seen in let's say the past cases, or what sort of different cases that you have seen, and just because of having this trust, the client really saved some significant amount as a result of it.
Absolutely. Yeah. So again, because the bridge trust is a foreign asset protection trust, you're going to have 40 years of all the case law from the Cook Islands and foreign asset protection trust there at your strength and disposal. And that's 40 years of actually very strong support of case law. That's why it's the gold standard across the world. Yeah. And so just to share some of the, like you said, the success stories, there's the famous Anderson case with the SEC coming after, $36 million. And this case settled for pennies on the dollar. And I don't condone this behavior, but I like to teach through extreme bad cases. The Andersons were crooks. Like, they created a Ponzi scheme. They stiffed $36 million into this trust.
Wow.
And the $36 million was safe, even from the government, the man who has infinite amount of resources and can come and sue you in the Cook Islands. They forced the government to settle for pennies on the dollar. And you have the same thing with the Grant case, crooks, stiffing the IRS for money, same thing. And then some other ones, there's a $34 million malpractice suit that settled for $1 million, under $1 million actually.
Wow.
A $5 million judgment that settled for $200,000. We had a $75 million personal loan suit that settled for $5 million with payment over, spaced out over, I forget how many years. $32 million bank loan dispute that settled for $2.5 million.
Wow.
We had a doctor who had $1 million worth of malpractice insurance and got sued for malpractice and had a $3 million judgment. That ended up being completely dispersed and went away.
Wow. And now, speaking of this trust there, Brian, what sort of net worth is needed, or you advise people? Sometimes, like nowadays, 5-10 million is really not much, in my opinion. You really want a really high net worth to, sort of sustain and support the annual costs and things like that. Mm-hmm. Give us some guidance in terms of, dollar numbers, if you can.
Of what different levels people should think about.
Right, exactly. Mm-hmm.
Yeah, so when you're just starting out, I don't even care if you're just starting out a residency and you want to invest, or you're just like, hey, I'm a nurse or a cop firefighter and I'm going to go invest in a couple of doors. Start with an LLC and insurance. That's your starting point. It's going to be affordable. Mm-hmm. Like, don't pay for the Taj Mahal until you need the Taj Mahal.
Right.
Once you get to 4 units or like 250,000 net worth, that's when you need to start. At that point, you have a couple LLCs. You need to start thinking about your tax filings and streamlining and where you're going to grow from there. Mm-hmm. That's when you bring in the management company, create the system before you need it to where you're going, and then make your CPA happy and get your business set up properly.
Sure.
When you hit that 500, you think it's going to be a little low. When you hit that 500,000 net worth mark to $1 million is when we actually start talking and having clients bring in the foreign component, the bridge trust. That's simply because that's a lot of money for most people to make. And one lawsuit can completely wipe that out.
Sure.
And they're not going to be able to rebuild that. And so generally most people want to protect that retirement nest egg.
Right.
And so that's where we see like the highest profile is around 500 to 1.2 million. Generally, when you're getting to 5 or 10 million, half the clients already have some sort of structure on this, and we just have to clean it up and then bring in a bridge trust. And that's fine. Those clients understand the need for it.
Right.
The biggest damage I see done is between 1.2 million and 5 million.
Right.
And that's just, I think, because most of those clients are used to doing everything themselves, and they built themselves up from scratch.
Sure.
And they think that they can create legal systems on their own and manage them on their own.
Right.
And they're not past that mental mindset of utilize your team. So
Sure.
I would say utilize your team, realize what level you're at, and then scale as you need to go. So realize you may be just at LLC level, but then 2 years from now, you might need that management company. And then depending how good of an investor you are and how successful you are, that 250 or 500,000 can go to 1 million really fast. And then that 1 million, you're going to now be most likely an accredited investor,
Sure.
getting deals no one else is getting. And then that 1 million to 5 million, it grows very fast. So that's when you need to be preventative and plan beforehand and get that asset protection trust in, so that you can realize I can sleep well at night knowing I have the system in place if things go belly up.
Absolutely. Thank you, Brian. It's been a pleasure knowing you. Tell our listeners like where they can learn more information about you, your contact information, and maybe perhaps learn more about the bridge trust you're talking about as well.
Yeah, they can jump on my website, www.btblegal.com, and I have lots of educational videos and brochures and pamphlets, and lots of frequently asked questions that we weren't able to have time to touch upon here.
Sure. Mm-hmm.
They can email me, Brian, BRIAN, at btblegal.com. I like answering questions. I used to do paid consultations, but I just do free consultations now. Because I think most people are afraid to talk to a lawyer, and especially if they're shopping around and wanting to hear other opinions, they don't want to pay multiple consultation fees.
Sure.
I would rather have people just get the information, make an educated decision, get an evaluation. What you do from there, I just want you to be educated.
Right. Awesome. It's been a pleasure, Brian. I appreciate all the expertise you shared today. I'm hoping that we can again touch base on some in-depth topic around this, and host you on another future episode of it. I appreciate your time today. Thanks for coming on.
No, thank you for having me.
Thanks for listening to Premium Cashflow Real Estate Investing Podcast. Please join us at premiumcashflow.com to sign up for weekly updates, research articles, and more. We will see you again for another great interview with an expert guest.